Hello, David Martin here, and I want to talk a little bit about the model case, the model long-term disability case. And this segment is going to be about appeals or reviews by the insurance company of an adverse decision which they previously made. So before we talked about the claim process and what constitutes a model claim process, now we're at the stage where the insurance company denied your claim and said, yes, you are hurt, you're injured, or you're sick, and you say you're not able to work, but we don't agree, and we think you can work. And so we're denying your claim. A lot of people are surprised by such a decision, and they're even hurt by such a decision because they thought if they're forthcoming and honest with the insurance company, they're going to pay the claim. Well, it doesn't always happen that way. They'll say, we certainly sympathize with your loss or with your problems, but they don't preclude you from working. Or they'll say, there's not enough objective evidence that you're not capable of performing your job, or any number of other things. Well, that's all part of the game that they often play. And so it is important that you, again, pull out your policy and look at the rules regarding appeals or requests for a review of an adverse decision. Those mean the same thing. We just call them appeals because that's shorter than saying a request for review of an adverse decision. If there's anything about the decision that is detrimental financially to you, then it's adverse. And so you should be able to appeal that. So you receive your claim decision. Let's say you receive it on January 1st. And in that claim decision, you're told that you are not disabled under the definition of disability in the policy. All right? So you pull out your policy and you look at it again. And you note that the policy says you are required to be provided at least 180 days to appeal that decision. All right? So if the decision was denied on January 1st, and that's the date of the letter, the first question is, what date did you actually receive the letter? And that needs to be documented. I would keep the envelope if you received that appeal decision in an envelope, because sometimes the letter may be dated January 1st, but the mail doesn't usually run on January 1st, does it? So the envelope may not be postmarked or even stamped on that date. It may be a week later or sometimes even 2 weeks later. Insurance companies often will have these letters written where the adjuster is working from home, and then it's transferred over to some mail facility where postage is actually affixed to an envelope and the letter is put in the envelope and sent out. And that sometimes can be 2 weeks. So you need to note the date that you received the letter, because the date that you received it is the date that you run the 180-day minimum time frame from. Okay? That 180 days is pertinent because that's the time within which you can submit an appeal request. That's the time frame in which you have to gather all of your evidence and provide it to the insurance company. You may say, well, that's 6 months just about. Why so much time? It takes time for you to order your medical records. It takes time to get opinions from physicians. It takes time to get opinions perhaps from a vocational consultant. It takes time to get the claim record and go through the claim record. So your first order of business after you know what your deadlines are in the model long-term disability appeal is to obtain the claim record. And you obtain that claim record so that you know the detailed reasons why your claim has been denied. That is also a chance to document what is in the claim record, because sometimes information is withheld from the claim record, sometimes intentionally, maybe sometimes unintentionally. But that's what you need to do, is evaluate what's in the claim record. Do they have all my stuff in here? Everything that I submitted previously. They said they ordered records from my doctor's office. Did they order them for the requisite time period? Okay, because you may have been sick for a year and they only ordered records for the last month. And at that point in time, you were just maintaining the medication regimen that you're on and only seeing the doctor once a month. And if they didn't go far enough back, maybe Maybe that's part of the problem. So you order the claim record from them and they're required to provide that, and they get 30 days to provide it. So once you receive that claim record, then your next order of business will be to obtain the evidence and the information that is needed and that's missing in order to win your case. That involves some strategy, and usually it's at the appeal phase that I would strongly recommend that you have an attorney. In some instances, it's helpful to have an attorney during the initial claim process to help marshal that along. My experience is that a client ends up paying less in attorney's fees to assist with the initial claim and to make sure it goes smoothly, and then much more in order to fix many of the problems that may have popped up during the appeal process. Nonetheless, some people want to save the money, and so they don't wait. They wait to hire an attorney. They don't hire an attorney during the initial claim when it might have been less expensive. But that's okay. At the appeal stage, you have a problem, and if you don't address the problem and fix it, now's the time to hire an attorney to assist you with that. Once you obtain all of your information, then you very thoroughly discount every single reason that they have relied upon to deny that claim with strong and compelling evidence. The insurance company, once they receive your appeal, and you've submitted it now within 180 days of the adverse decision receipt, then they have 45 days to make a decision. Okay? So since you received the adverse decision, about day 225 is supposed to be the maximum when you should hear whether they're going to change their mind and pay your claim. Well, there can be special circumstances again that arise, and they can take another 45 days as long as they provide notice to you that they are doing so, and they provide that notice within 45 days. Okay? So you submit your appeal by day 180. Then on day 44 or before that, they provide notice to you that they need another 45 days, and here are the reasons why. These are special circumstances beyond our control. And then they're supposed to make a decision at least by day 270. That's a good bit of time to go without a disability benefit, but that's the process that they are allowed to utilize in order to review your claim. Now again, just like in the initial claim process, there can be tolling. So if they request information from you, such as, we need evidence from your employer as to your job duties, and the employer's not giving it to us, can you get that for us? And so if you can get that and give that to them, then that's good. That stops the tolling. At least you need to check on it and then let them know, I can't get that to you. The sooner that you do that, the better. But if they ask for information, then you need to respond promptly, because each day that you're waiting on your claim decision is important to you. And that clock stops if they make a request for information. All right? So finally, day 270 comes, and it's time for them to make a decision. If they make their decision in a timely manner, then everything has been done correctly. Whether that decision is adverse or not, they have done their review. Okay? If they don't make a decision by day 270, then there is an issue of sorts. And that means that the claim again has been deemed exhausted, and you're allowed to go to a lawsuit. Now some, not all, but some policies or plan documents will provide 2 appeals. So that entire 180-day plus 45 days plus a potential additional time frame there of an extension can take up to 270 days all over again. That seems like a long time, but that's why you need an attorney to help you marshal this process. There's a lot of information that has to be put forward to the insurance company, just about the same as if the attorney is presenting a case at a trial. It's just about the same thing. A lot has to go into that in making that presentation. So that is your model appeal process for a long-term disability case. 1 appeal, maybe a second appeal, and then after you've done both of those, then you're ready for litigation. And we'll talk about that another time. Thanks.